If you have been injured at work and the claim that you have put in is disputed by anybody or any party, you may hear the word QME, you may be offered a QME. So what is a QME to you as an injured worker? It's a Qualified Medical Examiner. This is somebody that has studied to become a QME and applied to the state and obtained a certificate saying that they are qualified medical examiners. They can evaluate an applicant and resolve their medical disputes only. They're not resolving the whole case. They're just answering medical dispute issues so as the attorneys or the judge in this case can resolve it. Now, a QME can be with or without attorney involvement. For instance, if the applicant or the person or the laborer was injured and he was treated and he has a dispute with the doctor that's treating them, his decision either to send him to work or to finalize them or to the degree of impairment or the treatment recommendation, he may petition on his own the DWC, the Division of Workers' Comp in the state of California, and that's online. He may petition and ask for a QME. The state then will send him 3 different QMEs in the area and field of injury he has. And most common injuries are orthopedic injuries. That means spinal cases, knee cases, neck, back, shoulder, hand. Those are the majority of injuries that a worker goes through. So the state will send him 3 doctors within his area, within a 5-mile radius or thereabouts. He will choose one of those 3 and he will call him, make an appointment. He will see him. Now, the other pathway is that if the applicant is represented means he has an attorney, he has a big disagreement with his company, and he gets an attorney to represent him, then him and the attorney will petition the Division of Workers' Comp, DWC, for a QME. And then they will also be given 3 doctors in that area of specialty. The applicant attorney will strike one of them, and the defense attorney will strike the other, and there will remain 1 out of 3, and that one will become your QME. You will make the appointment, or the attorney that's representing you will make the appointment, and you'll go there, and you're allowed about total of 3 hours of your time for that evaluation to take place. And it should be done within like 30 to 60 days from the time you call in. They should accommodate you with an appointment. So what do you expect at the appointment? You expect to give a detailed history of the injury, and you, as well as the doctor, as well as any party involved, are all mandated to tell the truth about the injury. So if you've been injured elsewhere, or if you're injured before, you're supposed to tell your doctor or the historian taking the history the same thing. So you give the history first of what happened to you, how you were injured, whether a specific injury or a specific date, or is it due to repetitive activities. And when you do that, the historian will put it down in writing. He will put down also whether you have had any prior problems in that same area you're complaining of. You're supposed to tell him, because the honesty will prevail always. And if you do that, an accurate representation of your injury will occur. The system doesn't mean to you that you're only supposed to injure your back this one time. You could have injured it before, and if you injured it again, it will be referred to as exacerbation or aggravation. Aggravation means you have increased your injury or impairment by at least 1%. So after you do that, you're evaluated by a physician in that area of specialty. In my area would be an orthopedic surgeon like myself, or any other doctors in our Pacifica Orthopedic Medical Group. We have 3 additional orthopedic surgeons, Dr. Ram Mudian, Dr. Emil Wakim, and Dr. Robert Ahern. Any one of those, in addition to myself, can evaluate that process. You will have to ask for the specific doctor because that's the one who has to do it. And by law, the doctor himself cannot switch you to another doctor to see you for him. I cannot ask another doctor to do the work for him. So, one doctor and at the location you requested. That means you cannot, if you ask to be seen in the Riverside office, for instance, the doctor cannot bring you down to my Huntington Beach office for their convenience. They have to see you at the office you selected closer to your home or work. So, when you get to see the doctor will go over the history with you that has been prepared. Then, if he wants to order x-rays, he orders x-rays or whatever diagnostics he needs. And then if he has records, he will review the records at that time. And then he will perform a physical examination in the area of injury. So the examination will be detailed for that part. For instance, if you injured your back, lower back, the examination will be to the lower back and lower extremities, and it will detail like range of motion, muscle spasm, localized tenderness, neurological deficit, like if you have sciatica or if you have inflammation only or if you have nerve root impingement. The doctor will know what to say. So they will report that. In their report, they will enter the diagnosis, and then they will discuss the issue of causation. That's very, very important. And again, I want to remind the people hearing my talk is that it doesn't mean that the person, if he was injured before, he cannot be injured again. Yes, you can be injured again. You have aggravated your injury or exacerbated it, but you have to tell them about your prior injuries so as you'll have an accurate report and an honest one. The worst thing you could do really in this case is not to tell them you've had prior injuries to that one injured area, and then they find out and they will consider that to be inaccurate or fraudulent, and they will throw away the case. So after all of that is done, diagnosis is done, the doctor, the QME, will discuss the issues of causation as indicated, and he will discuss with the parties. The parties could be yourself, the injured worker, or could be the attorneys on both sides, and that goes to a judge called the WCAB, Workers' Comp Appeals Board judge, that will go to him to interpret your report and to agree or disagree with it. Usually, the WCAB judge is referred to as a trier of facts. That means he tries the facts that you, as a physician, will put together, and he will agree with it or consider it as credible, and then tell the parties to proceed with settlement according to what you said. Your main job after that, after you discuss the issue of causation, is to determine work restrictions on the injured worker. What can he not do? For instance, can he go back to regular work, ditch digging or electrical or plumbing or whatever the case may be, or desk work for that matter? What are the restrictions from his regular job? How much can he lift? How much can he push? How much can he work overhead or whatever the case may be should be detailed in there. After that, the QME will discuss the impairment rating. Now we call it impairment rating according to the AMA guides, and that's given in percentages. That means 7%, 8%, 13% of losses that you have incurred from what you were before the injury. The 8% represented deficit or a loss from normal that you have incurred from the injury. And that's taken from your report. There is a division of the work comp system. It's called division of evaluation. What you do is a disability evaluation unit will take that impairment and translate it into disability factors. Multiple factors enter into that: your age, the job, the occupation, and where you live. And then they arrive at usually a higher number than your impairment, and that's called the disability amount. On that, the parties agree how much does that cost, and they usually settle the claim on that. Right after that, in your report, you will discuss what is called apportionment. Apportionment means how much of the injury occurred under the current employer that you have filed a claim on, how much occurred before, or how much is due to a disease process. For instance, if you have severe degenerative arthritis that contributed to the impairment, must contribute to the impairment, and cause you difficulties in activities of daily living, for it to be used for apportionment purposes. That means you had arthritis and didn't affect you at all. You cannot rate it unless specifically it's in the extremity like the knee, whereby there is, based on the millimeters of the joint, you have to assume that that impairment existed before the injury. Apportionment is in percentages and is divided according to how much injury in percent occurred under that the new employer you're claiming against, and how much occurred previously in car accident or in a separate slip and fall, or occurred due to disease process. And that the doctor, or the orthopedic surgeon in this case, will have to provide a detailed discussion why he's giving that apportionment. He cannot say just 10, 10, 20, and 60, but he has to tell why he's giving those percentages. And that's very, very important in this case. And for that purpose, the doctor has to be knowledgeable and also credible. So after apportionment, the doctor will discuss future medical. Initially, future medical was accepted verbatim. Whenever a QME would say or an AME would say, will be accepted. But now, if it's not credible, it can be disputed. That means there is a way that the company says, hey, that's way too much. I'm going to send it to the IMR, which are other physicians who will review your recommendation and tell them, hey, this is yes, this is reasonable, or the other one is not reasonable. So it is very important to think of this word when you are a QME. What is a reasonable medical provider would say in his report? And that usually is done also by the physician under the penalty of perjury. And therefore, an affidavit at the end of the report will include his signature indicating that I'm doing this under the penalty of perjury. A few things people should know, and the QMEs should know, is that number one, they have to do the report at the time designated. Number two, they have to do it in the location it's been designated by the Division of Workers' Comp. And number three, it has to be reasonable, honest, and most of all, accurately representing the injured worker's injury and ability to return to work. I was questioned earlier, what's the difference between AME and QME? Really, actually, the report is the same, but the difference is that the AME usually is picked by both parties. He doesn't have to be QME by the state certified, but preferably that way, that means he's knowledgeable in that field. An AME is referred to as an agreed medical examiner. That means both parties, both attorneys, one from the applicant side, one from the defense side, or the insurance company itself, would agree on a doctor, myself or others, that they have known to be accurate, they have known to be credible, they have known to be expedient, they have known to be representing the injured workers' losses accurately. Some AMEs are, will take their time producing a report and they're not timely and they shy away from them. And that's why myself, we try to produce them timely. And if we have the records, we produce them within a week's time after we go through the records in great detail, produce the agreed medical examination, and provide same report as a QME, but will be based on the knowledge and expertise of many years, in my case, almost 49 years in orthopedics. It is an important difference is the knowledge and the reliability by the parties that this doctor is going to be credible and he's going to represent only the injuries that occurred and nothing more or nothing less. Initially, the labor code had reflected on the fact that if there is a medical dispute or dispute on medical issues, you agree on an AME. If you can't agree to an AME, then you go through the QME process. And that remains now, but there is an issue now with finances as well as whether you can use an AME instead of a QME. Let me tell you what the difference is. If you pick an AME, the word that the AME gives you is usually the final word from the impairment point of view. You can depose him and disagree with him and see if he'll change his mind. On a QME, on the other hand, whether he is knowledgeable, whether he's new to the business, whether he knows what's going on or not, depends on which QME you choose. Now, the QME report can be held against a PTP, a primary treating physician's report, and the parties may choose one or the other of those two. While on an AME, you're relying on his historical background that this is a credible report and he will facilitate resolution of the case quickly. He knows what he's doing. He's not going to extend the case ad nauseum, and he's going to cut down the hemorrhage on both parties. If there is no benefit in extending the case, both parties will benefit from resolution. The applicant will get his settlement and will go on either to rehab or to another job less intense, and the insurance company may close the file or close the file partially and still give him medical care. In AME, it finalizes the case, usually finalizes the case, I must say, because sometimes you need some diagnostics in addition to that, but in general, it finalizes the case, and it's the last word from the point of view of impairment and apportionment